Hello everyone, welcome to Thames Valley Pod TV's legal show, and I'm with our resident legal expert Richard Mullett, the Managing Director of the Legal Partners. Welcome Richard, thank you for joining us today.
Neil, delighted to join you. Thank you for asking us on the show.
Thank you very much. Okay, good. Well, today we have a theme for today, which is the top 10 legal issues for small to medium enterprises, otherwise known as SMEs, as compiled by our listening audience. And are we going to do this in reverse order, or are we going to start at number one?
I think we'll start at number one, Neil, if that's all right. These are practical issues which people have emailed into us, yep. And we thought we'd run down the list and give some practical legal advice and areas for people to look at. Okay,
so I believe at number one slot we have funding.
Always important, Neil.
Always important. Money and shortage of it.
As you know, Neil, from our previous business dealings.
Indeed.
Funding and cash flow go together. Always a legal issue as well, because when businesses are growing quickly, ensuring their contracts work with the funding and the cash flow position is one of the key things to think about.
Right. Okay. So how is this dealt with from a legal perspective?
Yes, most businesses sometimes forget that the contracts they sign need to be fed back into the cash flows. Right. So that they know what commitments they've got, both on the customer, funding and supplier side, to the cash flow they've got available. You'll see as we go through our top 10 list, we'll come back to the issues of how important it is to refer back to cash flows and funding when you're negotiating your contracts.
Right, okay, and as you know, cash is king, but profitability is even more important.
That's exactly right, and if you get your cash flow right, the profits will flow from it.
Right, okay. So next on the list?
Yes, next on the list is contracts.
Okay, so what about contracts?
Contracts are the lifeblood of any business. They need to give you certainty and also flexibility. Let's take some examples.
Yes, do.
Most businesses have got customers.
Indeed.
We're trying to work out what's the best way to get the customer committed. Could it be by email? Could it be a standard contract you send out? Or right. A long-term agreement? Who knows? It depends on your business.
Right.
So the business needs to think about that.
Okay, now, in the case of an email, so we've had a lot of correspondence about this programme, for example, and there's lots of emails. Are they legally binding in any way, or does that depend on the words used in the email, or how does that work?
Yes, Neil, legally binding is a good question, because a lot of emails these days do commit businesses and people to contracts.
Right.
It is now, rather like using the telephone and just meeting face-to-face, you can form contracts very easily by email. So beware.
Yeah, so you could find yourself in an accidental contract.
You can do, yes, exactly.
With some possibly dire consequences.
That's right. Often we are settling disputes for clients where they have contracted via email. So think of it as though you're writing a letter or any other correspondence, and it could have the same effect depending on the situation.
Okay, and how does that differ from a verbal conversation where we may actually say, yeah, why don't you do this for me? Is there a difference in legal terms?
Not at all. You can form a verbal contract in the same way you can form a contract in writing or by email. Okay. So it's exactly the same principle.
But at least with email there's an audit trail, because it's very difficult to get rid of emails.
That's exactly right. So often we're finding clients bringing out emails which they've kept, which have either shown there's been a contract or proved there's been no contract formed.
Right. Okay. So at number 3, we've got employees.
Or contractors.
Or indeed, okay, employees or contractors.
Depending upon what you need in your business.
Right. Okay. So. Everyone knows what an employee is, but yep. There are obviously legal connotations around having such people working for you as well as contractors. So take us through that, Richard.
There are pros and cons of obviously having employees or contractors. Most of us have been employees at the start of our working life because we've worked for bigger companies.
Indeed.
However, as we all get older, we tend to work sometimes in a contractor way for businesses when they're starting up in particular.
Right.
Contractors are self-employed and do not sit on the company's books as employees.
Right.
They do not have the rights which employees have, and especially in the last few years, employee rights have increased in this country as a result of a lot of European legislation.
Right, now by rights, in this context, do you mean employment rights as opposed to legal rights?
Yes,
or?
That's right. No, because if you're an employee, you have the rights under law in employment law. If you're a contractor, you're likely just to have the rights as a supplier, which is different from employment rights.
Okay.
The waters are more muddied these days because a lot of people try to contract when in fact they're employees.
Okay, now this is where I think IR35 rears its ugly head, for which is more of an accounting thing than a legal thing.
Neil, that's right. And again, this is a more specialist area. The government has been keen to get to the bottom of people's status. IR35 is a government regulation where contractors, if they are really employees, will end up being taxed as though they're employees, not contractors.
And thus losing any nice tax optimization advantages that their contractor status formerly may have had.
Neil, that's exactly it.
And number 4 is always an interesting one for me as a marketing guy or former marketing guy, which is that of branding and trademarks.
Thanks.
So, Richard, what's the legal position with branding and trademarks? Is there a difference between a brand and a trademark?
The two go together. Most businesses these days have a brand as part of their marketing strategy. Most businesses forget that you can protect your brand by registering a trademark. Very simple to do. You can register it either in the UK or on an EU, a European-wide basis. Pretty cost effective for most businesses when they've grown to a certain level.
Right, but there are certain things that you can and can't do. I mean, it's not a free fall. There are certain things you can't trademark. For example, take a term, think of one at random, liquid bandwidth. You can't trademark liquid bandwidth, as I found out a few years ago, but what we could trademark was a logo type, a logo that encapsulated the principles of liquid bandwidth.
That's right, because most common words you cannot trademark, so people attach a logo to it, which enables them then to differentiate it from just the common word. Liquid bandwidth plus a logo can be trademarked.
Right. Would they need to be bothered by an international trademark or European trademark if their business is mostly in the UK?
If they're mostly UK based, if they do a UK search on the trademark website, details are available later on. You can actually check in advance whether the trademark has been taken or whether you are likely to be close enough to the trademark to be infringing it.
Okay.
It's a little bit like choosing domain names for websites. It's a similar principle.
Okay. Now, different industries may have the same phrase or terminology but meaning a different thing. So in one industry you may have a trademark. Does that mean it's protected in another industry? Or is there no protection there if you're not doing the same kind of service or product?
Yes, Neil, you're exactly right. You need to actually think of trademarks as referring to each industry. Let's take a simple example. If you think of the word polo, that covers Polo Mint, that covers the Volkswagen Polo car, and Ralph Lauren Polo clothing.
Indeed. And some sports.
Yes, in the polo sport. And each of them coexist with different trademarks to protect them in their own industries.
Okay. Offices, serviced versus leased. So if you're a new business starting out, this is something you may want to think about, or indeed working from home.
Yes, that's right. Most businesses, when they grow, they often start from home, but they come to a certain trigger point where they need to find some offices. People often forget the difference between a serviced and a leased office in terms of what they do when their term comes to an end. If you're a serviced office, you're unlikely to be able to automatically renew except by negotiation with the supplier. If you have a lease and you've taken proper advice, you have more rights to protect yourself at the end of your term. Often, if you're going to take a lease of a building, you will be responsible for supplying the various bits which make up the office in terms of cleaning, in terms of receptionists, in terms of maintenance.
Right.
If you take a serviced office, that's often bundled together.
Okay. So a little bit of outsourcing for facilities.
That's exactly right. But most people forget that there is a difference and need just to be aware of that when they're growing. Okay.
And we're at position 7, which is structure. What do you mean by structure, Richard?
What I mean there, Neil, is a lot of people when they start in business need to think, okay, am I going to start as a sole trader?
Uh-huh.
Am I going to get together with other business people I know and either form a partnership? Or am I going to trade through a legal entity such as a limited company, which will give me limited liability? I would obviously have some other shareholders with me.
Okay, now what does limited liability mean?
It means when you're trading, if there's a problem, a legal problem which comes up and you encounter damages, that the company has limited liability. So the shareholders just put in their money. If there are problems with the company and it has to be wound up, their liability is limited to the shareholding they have put in.
Okay, so if they put in 500 quid, then they'll lose 500 quid and maybe not £500,000 of their house.
That's exactly right, Neil.
Right. Okay.
Yes.
Now, if you're a sole trader and you don't have that protection through the structure of your company, presumably it would behoove you to have that protection through some kind of insurance policy.
That's right. A lot of people take out what you and I would call professional indemnity insurance. If you're supplying a service, you have to have public liability and employer's liability insurance also if you're employing people. So there are various other ways to protect yourself. You don't have to be a limited liability company.
Okay, so you can mitigate the risk either by insurance or through the structure of your own company.
That's right. The key thing here is to look at the pros and cons of each structure. Probably sit down with your accountant or your tax advisor to see the benefits and the disadvantages of each structure, and then find you the right lawyer who can get things set up for you quickly.
Okay, and there's no wrong or right way, but I would imagine that most large organisations would be a limited company.
That's exactly right, Neil. Most large companies are limited liability, or they're government departments, where obviously they're part of the government.
Yeah.
A lot of businesses start out as sole traders or partnerships and then convert into limited liability companies as they grow.
Okay, that's pretty clear, I think. And another one that we kind of touched on a similar topic earlier, which is one of debt collection. So this is a big problem for most small companies, is getting paid by the large companies they've provided to. And obviously that's a source of contention. There's often programmes on Radio 4, for example, about this topic. So how can a small company ensure that the big companies actually pay them for services and goods supplied?
This is a combination of the practical and the legal. Practical is obviously making sure invoices have been authorised and you know where they are in the process. A lot of big companies have payment runs twice a month, so finding out whether you're on that payment run or the next one is usually the most important thing.
Right.
If you do encounter problems and you need to resort to the courts, there are some simple processes in the county court for people to follow. You can do a lot of this yourself. The courts now have all the paperwork online on their websites.
Right.
Find out the local court where the person or the business is resident, where you're trying to claim your debt from, fill in the forms and go through the process. It's quite a simple thing to do these days.
Now, a couple of questions follow on from there. What if you're dealing with a company that is not in the UK?
More difficult, Neil. That's exactly right, because you're relying on whatever the process is abroad, and that can be more costly and be more difficult. Practical ways, obviously, perhaps try to get paid up front for some of the work before you do it. Form a good relationship in terms of payments, get used to how they pay, and that should hopefully avoid the problems. But yes, it is a difficult legal issue because you're going to be relying on what happens in the other country.
Now, a common characteristic that I've noticed with people who start up on their own, they may have been in the corporate world where there are lots of departments that deal with other services, for example finance and collecting of cash and so on. A common theme I've noticed is a reluctance or almost an embarrassment to ask for the money, and almost in a position of being afraid to ask for the money, which of course is not good.
Exactly, yeah. Most people, I think, respect you more if you are prepared to say, I've done the work for you, we've agreed some payment terms, could you please ensure that I get paid on the agreed payment date?
Okay, so just keep in touch with the payments department.
Yes, exactly, the accounts payable, and make sure they've received the invoice signed off by the person in the business who you've been doing the work for.
Okay, so establish a good relationship and keep in touch and track where your invoices are. And if worst comes to the worst, either through negligence or through some kind of deliberate ill will, then get in touch with your friendly lawyer, but check out websites first.
That's right, and if you want to do it yourself, go and look on the county court websites and fill in the paperwork yourself.
Issue number 9 on our top 10 chart of SME issues, and that is renegotiation. What is meant by renegotiation, Richard?
Yes, I just want people to realise that there's nothing wrong in going back when you've negotiated a contract and renegotiating it, because your business requirements may have changed. If you are prepared to put a new proposal to a customer or a supplier, sometimes even an employee or a contractor, your business will change as it grows. Be prepared to make your contracts change to fit the new circumstances of your business. Okay,
now is that something that you can actually work into the contract as a standard clause, that this is all very well but things may change and therefore we reserve the right to renegotiate the terms of this contract?
The best way to do it is to be able to give yourself notice to terminate the contract and then agree a new contract. So beware of contracts where you're having to give long-term commitments or where you are required to do things which you think you cannot deliver in the future. Make sure you've got some flexibility. Comes back to our second point, Neil, where we talked about contracts